Good afternoon. You can be seated. The matter before the court is Oxford 2484, Thomas Rideout versus Martha, is it Vandervolk? Volk, okay. And I see counsel are present, and I assume ready to proceed. First, can I ask you both to identify yourselves for the record, saying your name together with the name of the party you represent, starting with the appellant.
Rideout.
And Attorney Amy Dietrich for Martha Vanderwalk, who is the appellee in this case.
Thank you. And we are being streamed live on the web. We've had some technical difficulties in the last few days. So Matt keeps nodding his head when I say that. And we are being streamed live on the web with regard both to audio and visual these days. Attorney Glenn, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. Chief Justice, Associate Justices, may it please the court. The significant issues before the court are both substantive and procedural. Our family court system has failed these litigants. Substantively, the lower court cannot determine a valid contract with a unilateral decision that a transfer of shares for a nominal fee equates to a gift of over $400,000. The court inferred a donative intent rather than relying on the literal terms of a contract. The trust, this family trust, invested in Martha and Tom's dream to own a sporting camp. In fact, after a hearing on the defendant's motion in limine, the lower court stated, and I quote, "If the funds used to purchase the property were intended as a gift at the time of the purchase, that was not borne out by the evidence before the court. The funds to purchase the camp real estate was a contractual obligation that in all practical aspects imposed obligations and restrictions on both parties. When the trust sold its shares to Martha, it simply removed an obligation to continue to make payments back to the trust. It was not a non-marital gift of cash." When asked by the referee specifically, Jeff, the brother, said they intended the obligation to repay the investments would be eliminated once these shares were transferred back, and Martha would be free of that obligation. And these shares that were transferred back to Martha were transferred to Martha, not MPLLC, the corporation. Second, the court has failed to properly recognize the marital component of the real estate. The real estate was acquired through the actions of both parties during the marriage. The real estate was improved through the actions and contributions of both parties. Most notably, Tom was responsible for the day-to-day operation, and all of his funds, all of his earnings went into this marital pot. The lower court, and again in its ruling on the motion in limine, found that, quote, "the commingling of funds and income from each party used for camp purposes and the plaintiff's contributed marital labor establishes a marital component to the MPLLC. The prime point of the Warner case, as referenced in our brief, is that material participation in a non-marital asset during the marriage creates a marital interest. The court cannot, without a hearing, undermine a prior court order on this fully litigated issue. Procedurally, this case was transferred to a new judge without a trial and the opportunity for the parties to be heard. And this new judge cannot decide to deviate from the main rules of civil procedure. The proper process was not followed. Proper notice was not provided in accordance with the rules. The court laid out options, including remand. The parties selected to do judicial settlement conference. It didn't work, but then they were not offered the option again for remand. Substantively also, the court failed to properly assess and improperly divided the investment accounts of the parties. The value of the investment accounts varies daily. Any increase in value of the marital component of these accounts must be considered in the final divorce decree. The court assigned a sum certain. 62% of one account was determined to be marital. 100% of another account was determined to be marital, subject to division. The stock market, these are investment accounts. The stock market has changed considerably.
Counsel, I see that the green light is on. Can I
Yes.
follow up on the point that you're making on the accounts? Are
Yes.
you arguing for, in this case, let me back up a little bit. In
Yeah.
this case, as opposed to the case cited in your brief, the judge and the referee made an allocation of the accounts by dollar figure, not by percentage or anything like that, correct?
Correct.
Are you saying that that is always incorrect? That you cannot, if you have a $1,000 account, I can't say you get 500, you get 500. I must say 50%?
If it's a sum certain, if you say, I have $200 in an account on this date, we're going to divide that account. That's $200. We're talking about investments. We're talking about the stock market.
Well, accounts
So
of any
it's
kind.
the
I'm just
increase in-
saying. So are you suggesting that there is a rule that there has to be an allocation essentially by percentage rather than by dollar amount?
I'm saying that
Always.
the case cited in our brief, the Austin case, does indicate that it must be the value as of the date of distribution.
Well, but in the Austin case, the actual divorce decree did it by allocating a portion of the account rather than a dollar figure, and then it came back later. And so I'm going to suggest that that's different. What I'm asking you is a little different, which is you seem to be arguing for a rule, and I'm just trying to clarify this, that it is never proper to allocate by dollar amount as opposed to by essentially percentage.
Never is rather strong.
Okay.
I would use, I believe when one of the briefs I was reviewing in preparation for today, I think Justice Meade said the standard answer is it depends. It could, but in this case, because of the volatility of the stock market and the increase in value, this case has been going on
But
for
it
4
could
years.
have also decreased in value.
It could. And I've had situations like that where a house value was decreased during a course of a divorce, and the court ordered the one side to pay my client an absurd amount of money, but it was during the crash, and they had to pay. But in that case, they did it. Should they have? Probably not. They should have gotten a veritable. They should have gotten an appraisal.
But what is the basis for saying it should be a rule of law to do it that way, as opposed to, you told me the account was worth $50, I'm giving you 25 and you 25.
Well, because during the marriage, everything that comes into the marriage is marital, subject to division. We are 4 years into this divorce, and everything that was increased in value should be subject to division. And we can't ignore what happened with these parties' assets in the last 2 to 4 years.
So essentially what I think I hear you saying, but I'm not sure, is that had this divorce proceeded in front of a judge, the judge made a division and nobody appealed, there wouldn't be a problem, because presumably, although typically the amounts that are given to the judge aren't necessarily as of the day of trial anyway, and done it by dollar amount, that would be okay. But because in this case so much time has gone by, it's not okay.
So much time has gone by, Your Honor, but also...
So what's the rule of law is what I'm trying to...
I don't know.
Okay.
However...
Well, fair enough.
However, this case was scheduled for docket call and
I
trial
understand.
so many times. So Attorney Mitchell and I...
This case has taken a hugely long period
So
of time.
we would make an agreement. It's like, hey, we're going to use the balance in the accounts as of December 31st because we're going to go to trial in January. That was something we did agree to during the course of this exercise, but we're not there. And we're not...
Let me ask you another question. In this case, what we've got is a reference by agreement. We have findings by the referee. Goes to the district court. The district court accepted some and didn't accept others. And then had made some additional and different findings, obviously, particularly with respect to the MP LLC. Under Rule 53E, when there have been objections to the referee or to the reference's findings, it says the court shall adopt the referee's findings of fact unless clearly erroneous. What is our standard of review when the district court has rejected some of the referee's findings, as the district court did with regard to the MP LLC?
Well, what is your standard of review? Again, I would say that I don't know for sure, but I would suggest.
We kind of
that
need to know.
I would suggest it would be clear and convincing. There has to be factual evidence to support what she did. And she made so many.
Okay, well, clear and convincing is not an ordinary standard of review. So are we reviewing the district court's findings as to whether they are clearly erroneous? Do we have to first review the referee's findings and determine whether the district court could have found them to be clearly erroneous? I mean, is it like reviewing an intermediate appellate court at the first step and then going
Well, there
to
wasn't
the findings?
there wasn't an intermediate appellate court.
I know.
And our position is that the court should review the findings of what became the pseudo trial court, even though there was no trial before this judge. So her final divorce judgment, she had made a decision on our objections to the referee report. Then our position is the party should have been given an option to have a hearing to explain our objections, have another hearing, or remand.
And I understand some of the procedural arguments you're making. I'm actually going to, I'm not trying to play hide the ball here. So this is a real question. When we have, in this case, using MP LLC, right? Assume that the district court's findings, had that been the trial, finding that it was a gift and non-marital for the Class B shares or Class A shares, whichever it was. Let's assume that's supported by the evidence. But let's assume also it may have been supported by the evidence to have found that it was all marital, as the referee did. What is now our standard of review of the district court order?
I don't understand what you're asking me to.
How much deference do we give to what to the
Okay.
district? In other words, assume there is evidence that could support either finding.
I think the deference has to be to the finding of the referee, because the findings of the referee, he was the fact finder. There was no, the judge who made the decision in the divorce decree heard no evidence. She read paper. She didn't
Well,
have.
she received evidence,
She received evidence. but
and I'm going to suggest there was at least some agreement as to that process.
she received evidence and she made a decision, but the parties never got to challenge that, provide input to her after she did that. Nothing.
Well, usually you don't provide input to a trial court after the trial court makes a decision.
But this wasn't I'm saying the input to the court, this new judge, in her decision on the objection to her findings. So she made a decision on the objections. That we got that. Then we went back before her. She gave us 4 options. One was remand, one was refer back to the referee, one was go to a judicial settlement conference. We elected judicial settlement conference. Then that didn't work, so we ended up back to before this judge, and the only option she gave was she said, I'm going to have a hearing, but the only thing you can do with this hearing is to admit the admit the transcripts that were part of the referee process.
Counsel, my understanding is that she gave you an option where it was discussed and someone wasn't present, there was no objection filed subsequently, and then once the decision was made, there was no motion for reconsideration or any attempt at that level to deal with the process.
Correct, Your Honor, and that was me, that I missed a court conference, and she issued that order, but she said, I'm going to schedule a hearing. So our understanding was we could have a hearing, but then she limited what we could do at that hearing, which was the only thing to open up the evidence, to say, here's the transcripts and close evidence.
Thank you, counsel. And Attorney Dietrich? And I see that you didn't reserve any time.
I did, Your Honor.
But I'm going to let you get to the podium.
Good afternoon, Your Honors.
Good afternoon, and I'm going to start with really the same question I was asking Attorney Glenn. What is our standard of review?
With respect to the review of the factual findings of the district court judge, the standard of review is clear error. So if there is any competent evidence in the record to support her findings, we would argue that they must be affirmed.
Well, let me probe that a little. If the district court was supposed to adhere to all the findings of the referee that, unless they were clearly erroneous, then if the district court doesn't do that, isn't that an abuse of discretion?
With respect to the legal conclusion as to whether something was clearly erroneous, I would agree that this court reviews legal conclusions by a district court judge for an abuse of discretion.
So wouldn't that send us back to the referee's findings? And if they're supported, so they're not clearly erroneous, then the district court should have adhered to them, abused its discretion by not doing it, and then that's bad. So we have to remand, or what do we do then?
If this court was to determine that the lower court judge abused her discretion in finding that the referee had committed clear error in finding, for example, that MP LLC was marital or non-marital in some amount, then based on the agreement of the parties, I think the court would remand this case back to the district court judge. And that is in part because, as I believe Chief Justice Stanfill was intimating, or perhaps it was Justice Douglas, the parties specifically and at multiple points after the case came back from a referee said that they did not want this case to go back to a referee and authorize the district court judge to hold a limited evidentiary hearing and make additional findings, which is what she did, and she received no objection from the appellant as to that procedure.
But if we think it was an abuse of discretion of the district court judge on a particular point to find that the referee's findings were clearly erroneous, I mean, doesn't that mean we have to vacate what the district court judge did on that point and reinstate what the referee did? Or does it mean something else?
I think this court could vacate some portion of the decision and remand it back to the court with instructions, perhaps not necessarily with a specific ruling. The court could also affirm the decision on alternative grounds. For example, if this court were to say that they did not agree that with the district court judge that the referee's findings on MP LLC was marital in some portion and non-marital in some portion, this court could affirm the distribution, the overall equitable distribution of property based on tracing the value of the gift that Ms. Vanderwolk's siblings gave to her in 2016.
Well, but put it a different way, if indeed, and I don't know that I'm not necessarily suggesting it is, but let's assume that there is sufficient evidence from which a referee could have found that all of the value of MP LLC was marital. Putting aside what the referee then did with that, which I'm going to suggest under Littell versus Bridges was in fact clearly erroneous, but that finding of whether it was marital or not, let's assume there was at least some evidence that would have led to the supporting that. And then that means if it's not clearly erroneous, the district court judge can't jump in and change that, no matter how much the evidence may weigh against that finding, if there's sufficient evidence for the referee finding.
My understanding, Your Honor, is that the standard of review that the judge used in modifying the supplemental referee's report was whether there was competent evidence in the record, not sufficient or any, but competent evidence in the record.
Is that the correct standard of review?
That's our position, Your Honor.
Okay. Does this sound like something we ought to have supplemental briefing on? I mean, this could be, it seems to me like, and these are real questions. This is not me trying to argue something. These are real questions. It seems to me that the standard of review in this case could have a lot of consequence.
I believe, Your Honor, with respect to the standard of review, and I understand you're saying that's really two issues, which is what is the district court's standard of review, and then what is this court's standard of review of that decision. I believe the law is settled as it relates to the district court judge's standard of review of the referee's report. that is competent evidence in the record.
And I'm not sure we've had a case where the district court judge then said that it was clearly erroneous, and then it comes to us. That's where we're getting a little bit bogged down, I think.
Understood. I think that our position would be that the same standards that apply to any divorce judgment that is on appeal to this court as it relates to factual findings for clear error and abuse of discretion for conclusions of law would be appropriate.
So we don't go back to what the referee did if that was changed by the district court, but simply look at the district court's findings to determine whether they are supported in the record?
Yes, and also because in this case, Your Honor, the appellant has not in any way preserved or made this argument. I understand the court can, of course, raise any issue for the first time on appeal. That there is no issue that has been raised by the appellant in Mr. Rideout's brief that would address any standard of review issue.
No, but she certainly is arguing that it was erroneous to find that it was a gift.
And I guess what I would say to that is I think that she's in agreement that clear error is the standard of review. But I appreciate that. I also, if permitted, I just wanted to respond quickly on the investment account questions that were given to Attorney Glynn. I would agree that this case is not like Austin because here Mr. Rideout in his proposed order and all through the trial process requested a sum certain, and that is what the divorce court, what the divorce judgment eventually allocated to him. There is no requirement that any sort of division of marital property occur in a proportion as to a specific amount, and certainly not where a party hasn't requested it.
But let me ask you this. So it's one thing if you say there's an account and we're going to say, Mr. Rideout, you can have $50 out of that account, leaving the balance, whatever that may be, to Ms. Anarok. In this case, though, interestingly, in the division on some of it, for example, as it was divided by let's say the judge, on the union plan it said $89,854 to him and $46,851 to her. Well, probably as of about 5 days later, that was not the actual value of the marital component. I mean, and now we are 2 years later. So what happens to all, in that case, that's probably a bad example. No, that was, because some of it was also non-marital, but let's go with, if you use one of the accounts that was entirely marital, for example, and you do that. I mean, you're leaving money out there. What do you do? Where's the rest of it? Now that account is worth twice as much. Who gets that?
In cases where we have at the trial level a long lapse between when, say, financial statements were last filed or evidence was last submitted, there are multiple avenues that a party can take. They can file a motion under, I believe, Rule 41 to have the court take additional evidence. They can file a post-judgment motion for reconsideration. They can file a motion under Rule 60. At any point after this case was returned to the district court, Mr. Rideout could have filed any sort of motion asking the court to allow the parties to have a hearing that included the submission of additional information.
But aren't we actually leaving essentially unallocated money? If you look at the, whatever it was, the VWCU account, $9,500 to him, $18,643 to her by the judge. That supposedly allocated the whole account, but obviously that amount is different today than it was then. What do we do with that? Is that like omitted property?
It wouldn't be omitted property, Your Honor, but I think, as Your Honor pointed out to Attorney Glynn, that there's a risk that it can go both down as well as up. So I think the parties make a very calculated decision in what they ask the court to do in terms of dividing marital property. They themselves take on the risk that they might be, to use Your Honor's words, leaving money on the table.
But what if there's a residue that's now unallocated?
Then, Your Honor, I would agree, as with any, if there is property that's not divided, there could be post-judgment proceedings to
We're
deal with
inviting
limited
yet
property.
more litigation in this 4-year divorce?
Counsel, can I direct you to the Vermont property?
Yes, Your Honor.
My understanding is the trial judge included that it was non-marital property because the plaintiff had not met his burden to show the premarital value of the property. Is that correct?
It is, Your Honor.
Is that a correct statement of law?
It is in this case because what the district court judge was saying is that it was Mr. Rideout's burden to establish the value of, to establish that there was an increase in value in the property and what the value of that marital component is. And at the time of the divorce, the property that, the only evidence that was submitted as to values before the marriage was not the same property at the end. And so because it was Mr. Rideout's burden to establish the value at both points, that is my understanding of why the district court correctly ruled against Mr. Rideout on that issue.
So your client is advocating for it to be non-marital.
Correct.
And she doesn't have a burden to show what the value of that asset is?
The burden goes back to her if Mr. Rideout presented enough evidence to establish an increase in the value of the property and a value of that marital component.
So let me ask it this way then. Let me follow up on that. You put evidence in of when the property was acquired for the marriage. The burden then shifts to Mr. Rideout to show that there has been an appreciation in value and that there's some marital component involved. Is that correct?
Yes.
Does he need, in your view, does he need to show the specific amount of the marital component, or simply that there was marital effort, marital investment, there was marital labor put in, plus, in a general sense, plus the overall appreciation?
No, and I appreciate the opportunity to clarify. If Mr. Rideout had sustained his burden to establish an increase in the value of that property during the marriage, then the burden would go to Ms. Rideout Ms. Vanderwolk to establish the value of any non-marital component.
So you're saying the failure here was that he never established that there was an increase in value at all?
Right, so because the property in 2008 was not the same property that he provided evidence of the value of in 2021.
There was no baseline.
Correct.
There was
He
no
said there was
baseline.
Thank you, Your Honors.
Thank you. Ms. Glenn, I think you reserved 2 minutes for rebuttal.
Okay, were his questions about the Vermont property or the, okay.
Yeah.
All right. I'd like to address what Justice Douglas said about the increase in value for the Vermont property. The property change, it was impossible to, getting an appraisal for what it should have been in 2008, it was a different animal. It was a whole property during the course of the marriage. He had sold portions of it.
And we understand that,
Okay.
but was there established at all that it actually increased in value?
What was established was that marital funds went into that property. The marital funds paid off the mortgage. The marital funds built a driveway. The marital funds improved the property. That evidence was presented.
So what do we do? Let's assume there had been clear evidence of the value. We hadn't taken off a piece or something like that. And before the marriage, it was her non-marital property worth $100,000. During the marriage, they put in some marital funds by paying off a mortgage, maybe making improvements, and yet that property is now worth $90,000. What do we do with that?
Well, it's only worth $90,000 because of the parcels that were
No, I'm assuming
severed
it's
off.
the same property. It got improved, but say the market now tanked, so it's actually worth less even though they put improvements into it. Is there still, I mean, whose burden is it to say what is marital interest, and what do we do if there's no actual appreciation?
There still should be some compensation to Mr. Rideout for what he contributed to paying off the debt.
So
There should
she
be
would
some
then have to lose all the, if there was money lost on it, she has to bear all of the loss?
Except she also got the funds that for selling those pieces of piece of the real estate.
Well, I understand. I was
Okay,
posing
okay.
I was posing a hypothetical, which
Okay.
was not this case,
Okay.
of course.
Short answer is, it's a different animal. It was impossible to be able to come up with that figure, Your Honor. I don't know how we could have done that.
Okay, thank you. All right, counsel. Well, thank you for your arguments on this case. I'm wondering if it would be helpful to submit some supplemental authorities on the standard of review issue when we have a district court that has set aside some findings of a referee and what we do with that, or whether we just go ahead and review the district court. How much are you willing to do some supplemental briefing on solely that question?
Yes, Your Honor.
Yes, Your Honor.
Okay, how much time do we need for that?
How long?
2 weeks?
2 weeks is sufficient for appellee, Your Honor.
I mean, if you, tell me if it's not. We can give you more. I mean, we've got a
If we-
holiday
could we
coming.
30
No,
days?
we've got the holiday coming up and
Alright.
stuff. So why don't we say 4 weeks, and that'll
Fine,
get
Your
you
Honor.
not so that you're not working Thanksgiving Day.
Thank you, Your Honor.
And that is the only question we're interested in, I think, on supplemental briefing would be the standard of review of what to do when the district court rejects some of the findings of the referee. I think we've got plenty of cases about what to do when they accept the findings.
Okay.
All right, thank you, and thank you for the argument. We will take the matter under advisement, as is our usual course, and issue a written decision, but not until we get supplemental briefs on this issue. Thank you.
All right.
Good afternoon. You can be seated. The matter before the court is Hancock 2465, which I've just lost all my papers. State of Maine versus Raymond Lester. And if counsel appear to be present, would identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good afternoon, Rory McNamara for the appellant, Ray Lester.
Leanne Robin for the state of Maine.
Thank you. We are being streamed live on the web with both audio and visual. I note that there's also appeared to be a couple of cameras in the courtroom. And Mr. McNamara, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you. May it please the court. Counselor, there's only one thing this court needs to decide. Did defense counsel waive an intoxication instruction? That's the only argument that the state has made. The issue of waiver, therefore, is dispositive. This court, of course, adheres to the party presentation principle, so it won't adopt arguments that the state, in its discretion, in its strategy, has not briefed. To answer the question of waiver, I ask the court to scrutinize page 8 of the reply brief. That contains the passage of the closing argument which the state holds up as waiver. Remember, of course, waiver is the intentional relinquishment of a known right. Yet, on page 8, we see defense counsel suggesting that defendants' drunk driving means the state didn't prove anything more than an accident. On page 8, we see defense counsel arguing that defendants' drunkenness negates proof of murderous intent. Because this is the exact opposite of a waiver, the state's sole contention on appeal falls flat. Again, nobody is more familiar with the facts of this case than are the state's attorneys. Their decision to brief only the waiver issue binds this court, and appropriately so, on appeal. This case is that simple, and I'd open up the floor if there are any questions.
So you lost me a little bit on your opening argument there. You said that's the only issue. Aren't we talking about jury instructions on intent, motive, and premeditation, and on sentencing principles and things like that? You're saying that that's a fait accompli?
No, I'm happy to talk about those if you need, but from the court standpoint, what to decide, I understand fully well that jury instruction issue, there's a lot of complexity there, and I'm running headlong into a manual that is used very often.
Actually,
However,
let me just interrupt you. They're calling it the Alexander instructions. They actually, Bill Broderick, Justice Broderick,
Those
actually,
of us have been around for a really long time.
these
Right.
they're dog-eared and they've been photocopied 100 times. And this is what those instructions are. They've been used for the last 40, plus years.
Mm-hmm.
But you're saying, nope, they're wrong. You got to throw them out.
if you would like, Your Honor, would like to talk about that issue.
Well, you mentioned it. Why don't you
I'm
talk
happy
about
to.
it,
I'm
please?
happy to. There was an objection in this case, so I have a preserved issue, which is the reason I brief it, of course. But just because we've been using something for decades does not, of course, mean that it's proper.
True.
And I think the problem that I understood from the objection is giving all those may be correct statements of law, and in fact, they are each appellate proper standards for evaluating the sufficiency of the evidence. Whether or not those are proper for jurors to hear from a judge because they tend to overemphasize the state's talking points. They say, well, here's a laundry list of ways the state can prove premeditation, or not premeditation, mens rea, even though it may be indirect proof.
But it also explains, number two, what they have to prove. They have to prove for intentional or knowing. I mean, you can infer a person's state of mind, the mens rea, by the things they say, the things they do, because there's no evidence of what is taking place in another person's brain.
I disagree that these three portions that are briefed here relate to the elements of the offense in the sense that they're what the state has to prove. they are above and beyond that ways the state can prove its case. And therefore, I think they stray, and this is what I understood for trial counsel's objection, is they start to stray into gratuitous both comment and singling out of the state's case. Other words, stuff that would be an
at one
argument.
point you referred to it as pseudo law in your brief.
I think that some parts of that are pseudo law.
But
Parts
things
about,
like you may infer a person's intent or state of mind from the surrounding circumstances, any statement made, any act done. You may consider it reasonable to infer that a person intends the natural probable consequences of acts knowingly done. What's wrong with that?
because it's common sense, it's echoing the state's talking points, and the only reason it is law is because a judge is saying it and has said it for 40 or 50 years in the state of Maine.
Can I get back to the intoxication?
Please do.
For women? And I'd like you to respond to this quote from the Foster case.
The Foster
relates
case.
to intoxication. And explain that where the theory of the defense focuses on the absence of a culpable state of mind in respect to an element of the offense or an essential attendant circumstance because of intoxication, the presiding justice should provide, when requested by the defendant,
Yes.
additional explanation to the jury so as to prevent misunderstanding of the legal principles involved. Here there was no request by the defendant, correct?
Correct, there was no request, and there's only, I think that's
defendant
correct in all jury instruction cases, excuse me, where if the request is given and it's a proper instruction, then the justice is duty-bound to give that instruction. Yet, of course, we have obvious error review for those instances when counsel may have overlooked. And of course, it is not just the defense attorney's obligation, it is primarily the trial judge's obligation to properly instruct in the law, and of course, the prosecutor's obligation as well. And when we step back and look at the juxtaposition on the element of mens rea between all of these respectfully gratuitous instructions, a laundry list of common sense and things that the state does not have to prove, compared to the very important instruction that wasn't given, it's derelict of the court to not have given it. I will also note that, again, the state has briefed nothing other than the point of waiver, and certainly I would object to any basis for an opinion other than the waiver one.
But didn't your client take the position throughout the trial, no, I did not hit the victim here, my car never hit the victim here, it didn't happen?
Yes, there were two defenses, and I think they were both under the family tree, if you will, of failure of proof. State failed to prove the defendant did it at all. Secondary, but certainly central to this intoxication issue, is state failed to prove requisite intent. Even
Well,
the prosecution.
Except that's not really true. I mean, the defendant didn't seem to even want the lesser included instruction here.
Originally, but when the justice stepped in and said, I am going to give it, and the state said, yeah, I agree, it needs to be given, counsel reevaluated and said, well, we have all this evidence of intoxication. We're going to say that the state, in light, I mean, it's very clear from page 8 of that reply brief that that argument is being presented.
It's very clear that there's one sentence.
Oh, there are multiple sentences, Your Honor, in that 5-6 sentence long paragraph. And I think the whole note of it is this intoxication is something significant, and this is something that you need to look at. The defendant was intoxicated. You can't just assume that he was
But
there
doesn't
for
it
let's
make the
assume-
closing argument is, members of the jury, I didn't do this, but if I did it, I was drunk and I couldn't form a state of mind. That's
Oh.
that's a self-destructive closing argument.
No, I disagree, Your Honor. I think again, both of these are failure of proof arguments. And this court has anyway said several times that conflicting defenses, if this were, are totally permissible. And this is not that. This is simply a failure of proof on both of those prongs. And I respectfully completely disagree that this is waived. There is no way this is waived.
Can I return to the issue of the overall instructions? I just want to make sure I understand your arguments. And going to the standard instruction or the instruction that was given here on motive, that was that the state does not have to prove motive. That is the reason or reasons why a person acted as he or she did. Absence of motive does not necessarily raise a reasonable doubt respecting the guilt of an accused, nor does the mere fact that it exists establish guilt. Instead, evidence of presence or absence of motive is a matter for you to consider along with all the other facts and circumstances. If the instruction on premeditation and mental state generally included that kind of language, would that, coupled with the language that is given here, do you think that that would be satisfactory?
I'm not sure that I understand completely the question, so I'm sorry if I haven't fully tracked it.
No, that's fine. I probably wasn't clear at all.
Well,
So
they're difficult concepts.
in the instruction on premeditation, it says the state does not have to prove that he acted with premeditation, that is planning or deliberation to establish that the conduct was intentional. Rather, the intent may arise in the instance, and you can consider any evidence of premeditation if you find such exists. It seems to me that what you were asserting is missing, and that's what I'm trying to understand, is the obverse. In other words, nor does the fact that well, I guess with premeditation it's a little hard, but that established guilt. In other words, that this is just one of the facts that you can consider along with all of the other facts.
I think there are two ways in which this premeditation instruction, which is mirrored by the motive instruction in the following paragraph, are actually legally incorrect. Number one, it says in the final sentence of this instruction on premeditation, you may consider any evidence of premeditation if you find such exists. The obverse of that is actually required by the Constitution. By Johnson v. Louisiana, you may find reasonable doubt in the lack of evidence, not just in the evidence, like that sentence says. Another legal error, it starts with the beginning of that paragraph about premeditation, and it's mirrored with the sentence with the instruction about motive. The state does not have to prove premeditation or motive. That is correct as an appellate standard of review. It is not an element for the state to prove premeditation or motive. However, it is within the prerogative of a fact finder, a juror, to say, I am not going to be convinced beyond a reasonable doubt unless I see proof of premeditation or motive. Now, a prosecutor may say, well, legally that's not required in their instructions. For a judge to get up and say those things, that is commenting, that is highlighting the state's case, which is wrong under two strains of Maine case law.
So either you don't say it at all, or is it sufficient if it's balanced out by the fact that you can consider the absence as also raising, I know, I'm in the intersection, as you can consider the absence as also raising a reasonable doubt.
I think that's correct. The best way to do it is simply, as we do with most juror instructions, let's keep them concise as possible. Let the parties make proper legal arguments by themselves without judicial blessing. And that is, in fact, as I said, something that this court has said with two lines of cases, the Hernandez line of cases. Trial judges are not supposed to instruct jurors in a defense theory to generate reasonable doubt. The obverse of that must be equally true. We don't instruct the jurors in the state's theory of proving its case, also in the highlighting and singling out cases as well.
Thank you.
Thank you.
Attorney Robin?
Thank you, Chief Justice Stanfield. May it please the court. This appears to be a case in which trial counsel and appellate counsel have disparate theories of the case. At trial, Mr. Lester's contention was that the state could not prove that he took a sharp turn off the road, drove his BMW SUV over the grass, through the trees, and ran over Nicole McKemme on a walking path at Acadia National Park, hitting her with such force that her body lay mangled in an unnatural position and her intestines were spilled on the walking path. He was not using the excuse that he did it, but he may have been drunk, making his conduct merely reckless, not intentional or knowing. Rather, he contended that the state couldn't prove he was even there at the time of the murder. His suggestion in his opening and closing argument was that he had already left the park at the time of Nicole's murder. In his opening, he argued, the state cannot prove to you that maybe Raymond did it. They cannot prove to you that he possibly did it. They cannot even prove to you that he probably did that. No. And in his closing, he asserted, the prosecutor is saying that you can infer that Raymond was leaving because he had just run over Nicole and was targeting her. Or you can infer that he was having a bad time at the retreat and decided to leave. The prosecutor is saying Raymond left his bag behind because he was in such a hurry to escape his crime. Or you can infer that he knew Nicole was alive and would bring the bag home the following day. Mr. Lester did not request a manslaughter instruction, but the court gave it anyway. He was silent on a manslaughter instruction. And he did not request an instruction on voluntary intoxication because his position was that the state could not prove that he had engaged in any death-producing conduct. Under these circumstances, how can it be obvious error for the court not to have given the intoxication instruction? How can it not be waived? As for the other instructions that Mr. Lester now complains about on appeal, he conceded below that the instructions did not contain any actual inaccuracies. He has not cited a single authority finding error in these instructions, even though they've been given for years. And the instructions do not highlight or comment on any specific evidence offered by the state. For these reasons, there was no error in them. Finally, the court committed no error in setting the basic sentence for a brutal domestic violence murder at 40 years. Mr. Lester faults the brevity of the court's rationale as not supporting the 40-year basic sentence. But what more did the trial court need to say than was said to place the basic sentence only 15 years above the mandatory minimum for murder? After a series of extremely moving and heartfelt victim impact statements, the court took some time to explain why this murder of a beloved community leader did not warrant a life sentence. Then it turned to the Huey analysis to determine the appropriate range of a term of years, assigning specific weight to the fact that Nicole was a victim of domestic violence and the ultimate conduct and act of the defendant. And it highlighted the intentional nature of the act of running Nicole down with his motor vehicle and leaving her to die.
I see the green light is
Yes,
on.
I
Can
do.
stop you
Yeah.
right at that exact point.
Okay.
We have the judge's comments here. And as you point out, he identifies the circumstances, the basic circumstances of the commission of the crime, which is the first step. And says not that he did this, that he leave her to die in the pathway, special place, and immediately took flight. Still okay. Took flight from the scene. It kind of tells us about how he committed the crime. Took flight from the state, took flight from the country, and continued to remain in that status until he finally turned himself in. In other words, took flight to avoid prosecution. That had nothing to do with the four corners of the commission of the crime, the fact that he was leaving the country to avoid prosecution, does it?
That he was leaving the country to avoid prosecution goes to, consciousness of guilt, which was not an instruction that was given by the court. But the fact that he left her to die on the walking path and drove away.
Well, I think that's what Justice Mead is saying, is that initial that he left her at the path, left the scene. That clearly has to do with how the crime was committed.
Yeah.
And
But does running away to Mexico have to do with that?
Well, it certainly it is showing his extreme disregard or his of her condition by just leaving and not responding to any phone calls or any texts or whatever. And frankly, it's just describing the course of conduct. This is a continuous course of conduct.
Well, let me challenge you on that. The
Yeah.
course of conduct was killing the victim here. We've said the basic period of incarceration must be based solely on the nature and seriousness of the offense, without taking into consideration circumstances of the offender. The sentencing court determines the nature and seriousness of the offense by comparing the crime committed by the person being sentenced to all possible means of committing the crime. It really is the four corners of the crime. We look at how serious it is, how egregious it is, and the fact that he may have left her there to die certainly is part of the offense of the crime. But it just would appear that the fact that he didn't take responsibility, left the country to avoid prosecution, that would be completely appropriate, wouldn't you think, in the second stage of the thing, to look at, okay, now you look at the offender's circumstances.
I think it indicates his depraved indifference in terms of the victim's condition, and certainly leaving the scene is part of the course of conduct.
Yes, I agree with you there. It's the leaving the country and living outside the U.S. for quite a while.
Avoiding prosecution.
That was really a bad thing for, an offender to do, but it had nothing to do with the terrible circumstances of the victim's death.
Yeah. I do not believe that the completion of the story as to what happened affected the basic sentence of 40 years. The core of these facts, the domestic violence, homicide, the intentional nature of the conduct.
Okay, I don't mean to hijack the entire time of your time up there, but I just wanted to hear your thoughts on the sentencing.
Can I go back to the... Go ahead.
I mean, I think we can't, parse a trial judge's language too much and say, oh, that's first step, that's second step, that must have radically changed the 40-year basic sentence. In our view, the 40-year basic sentence in this case was low, given the comparable cases and given the conduct in this case, and that the judge was incredibly conservative in setting 40 years as the basic sentence and 48 years as the final sentence in the context of this case. And in fact, he gave Mr. Lester credit for turning himself in a month later in Cancun, Mexico. So he really used those facts really to benefit the defendant rather than to give him the sentence which the state thought he deserved.
Can I go back to the voluntary intoxication instruction? I understand it wasn't requested, and in fact, below it appeared the defendant didn't even want the manslaughter instruction. But in your brief in particular, I just want to make sure I understand. Are you suggesting that it wasn't even generated by the evidence? Your brief seems to suggest that it was not even generated. The voluntary intoxication.
Right. There was some evidence that there was some evidence that obviously he was drinking that night. There were some witnesses who thought he was inebriated.
Actually.
What?
A fair amount.
A
right?
couple of them.
And the broken bottle and all that.
Absolutely. Voluntary intoxication, I think I kind of conflated this in the brief. It's not an affirmative defense. It is just something that can be considered to determine whether the level of intent has been proven. And certainly that information was available to the jury. But the fact is that the defendant...
Do you agree that, let's put it this way, that had it been requested, that it was generated, had it been given, that would have been appropriate?
Had it been requested, had it been given, that would have been appropriate.
Okay,
that's
I just want to make sure
that
that's...
Oh, no, that's
okay.
correct. Yeah.
So really what you're going to is obvious error or waiver of that instruction.
Yeah. What are you to do when the defendant is actually making an argument that conflicts with that defense? He was trying to minimize his conduct, saying, hey, he was driving a little recklessly, he was drinking, but it didn't mean he ran anybody over. That was his argument. He just wasn't having a good time at the retreat and wanted to leave, and took a long ride down to Cancun. And so it really would not have benefited the defendant to focus on his bad behavior, disrupting the retreat with his reckless driving, his pointing his finger as if it were a gun at the members of the retreat, and blasting a rap song while the members of the retreat tried to gather for Juneteenth and talk to each other and share stories and music. That was not what the defendant wanted to focus on. And I think an intoxication defense would have focused exactly on his bad behavior in the hours leading up to
So you're saying
this
was a strategic decision and therefore it was waived?
That's correct, Your Honor.
And if it wasn't waived, it wasn't obvious error?
That's correct. Thank you.
And you're saying that, and given the tenor of the defense in this case, it's not like it was central to the defense to talk about he couldn't form the intent because he was intoxicated.
Yeah, the central defense is I wasn't there, not I ran her over because I was drunk.
Well, strategic decisions and waiver are two different things, aren't they?
Well, under Cleaves, this court has said that we're not going to give, just because a strategy doesn't work out, we're not going to redo that because you've made a strategic decision not to go forward with it. And it's not, unless the defendant was going to raise it, how And unless the defendant was going to have a theory that he was intoxicated, that's why he did it, or that's a defense, it wasn't intentional.
Is that how we analyze the obvious error in a case like this, assuming it's analyzed under obvious error? In other words, that the arguments the defendant was making were really premised on the fact that it wasn't me, I wasn't there, I didn't do it, versus I was there, but I was so drunk I didn't know what I was doing. And had he been arguing that, it would be obvious error not to give that instruction.
That would be a different case, and that is not this case.
In other words, it's only obvious error in hindsight, given the verdict.
That's right. I mean, I think this was a zero-sum decision. This was an all or nothing, murder or nothing from the defense point of view. And it was only when the judge brought up that, maybe the facts are generating some manslaughter here, that the state agreed and the court gave the reckless and criminally negligent manslaughter instruction as well. Unless there are any other questions, I'll sit down. Thank you.
There don't appear to be. Mr. McNamara?
Thank you. I'd like to read a little bit from the record because there's much more than one sentence. And again,
There are dual defenses here. They both stem from a failure of proof, of intent. The idea that he was drinking and driving too fast, he almost hit people, doesn't reflect well on him. Doesn't mean he intended to kill anyone. Talking a little bit more about the drinking and driving, skips down to, there's no evidence that he had any kind of murderous intent toward anyone. Did they rule out that it wasn't an accident? No. Did they prove it was intentional? No. We don't know. That's the point. That is embracing an argument, perhaps as a secondary argument. No doubt that defense counsel would prefer an acquittal across the board, but a secondary argument, this is how you make it as a defense attorney. Subtly, you invite it, you open the door, you plant seeds as to the doubt, and that's what's going on here.
But I think one of the arguments is if you talk about intoxication, it's going to bring out a whole bunch of bad facts that will undermine his primary defense, and therefore you can have a greater presumption that this was strategic and therefore was waiver.
Perhaps in some cases, but the state introduced all kinds of evidence of intoxication. There was no holds barred with that, and that was brought in by the state. And the reaction by defense counsel is, okay, they're going to give a manslaughter instruction. Well, we have this second defense here. We have the second thing that I have to raise in order to get down to that manslaughter.
Was that secondary defense addressed in the closing? Refresh my recollection.
That was the closing right there that I was reading from. That was all closing,
But did he ever say?
Which is why when counsel gets up and reads from the opening statement of the defense counsel, it's a little bit misleading because in between, things have changed, strategies have changed.
But defense counsel never says out loud, well, even if you find that he did, in fact, run over the victim, he was intoxicated and couldn't have created the intent to do it.
Doesn't mean he intended to kill anyone. There's no evidence that he had any murderous intent toward anyone. Did they rule out that it wasn't an accident? No. Did they prove it was intentional?
And what I hear you saying is if you're going to raise inconsistent defenses, it wasn't me, but if it was me, it wasn't intentional. You have to do it in a subtle fashion, and
Right.
that's indeed what was happening.
This is textbook how it is done. I will also object to the notion that the state has argued waiver and obvious error. The sole sentence in the red brief that pertains in any way to the obvious error standard is there was no prejudice in the courts not giving an instruction on a defense that was inconsistent with the defense theory of the case. That's going to the waiver right there. That's a waiver statement, that it was inconsistent because
And
they
are you
waived it.
suggesting that if we don't determine that it's waiver, then we have to just say, okay, then it was error? We don't then determine, if we say it wasn't waived, don't we then at least have to go to obvious error?
I will give a statement that will probably make me, if I may finish,
You may.
less popular than I already am with prosecutors.
I could make a quip, but I
All right, there is an epidemic of briefs, red briefs in particular, that address the issues on appeal. And if a defense lawyer does that, we have seen time and time again that an issue is not developed, an issue is waived, an issue is developed, not developed, it's abandoned and forfeited. The only way to get better red briefs is for this court to require them. Thank you.
Thank you. Thank you, counsel, for the argument here this afternoon. As is our usual practice, we will be taking the matter under advisement, issuing a written decision in due course. And with that, I believe we're in recess for the day.
All right.